Before you decide you're going to do process serving, you need to understand these critical pieces of information. If you do process serving, hop down in the comments below and let me know how much process serving you do. For me, process serving is probably 30% of our business, so it does really add up over time. The first thing you need to understand is what is a process server. In simple terms, a process server is an individual, usually a regular private citizen, just like you or me, and oftentimes it is someone with some other level of legal experience, such as law enforcement attorneys, other legal professions, and private investigators. The process server must also meet the requirements within the state, the county, or whatever jurisdiction they are working in to be allowed to be a process server. Every state is a little different with these requirements, so I encourage you to do some searching within your own state to see what requirements there are. You may need to be licensed, you may need to be registered, and you may need to be certified. A process server's job is quite simply to deliver legal documents to individuals, companies, and other legal entities to inform them that they are involved in a court case. How they are involved will differ widely from one case to the next case. In many instances, you may be serving the defendant in a case, be it a civil or criminal matter. As well, you may be serving a witness to the case or a subject matter expert in the case, and you could even be serving the plaintiff in a case. One thing you need to consider when considering adding process serving to your PI business line is if you have the proper protection for your business, and that is one thing OREP Insurance can help you evaluate. This video is sponsored by OREP Insurance and Working PI Magazine. OREP is a leading provider of private investigator liability insurance. Visit orep.org for a quote today. The documents themselves may be writs, such as a writ of garnishment, subpoenas, summons, complaints, orders to produce, eviction postings, and more. The documents you will be serving range from family court documents for cases involving divorce, child support, child custody, protection orders, restraining orders, evictions, and others. A huge question I get a lot is how long does a process server have to serve papers? And the simple answer is, well, it all depends. There are several factors involved in answering that question, such as what kind of legal action is being taken and what documents you're serving. In many instances, process servers can have anywhere from a few hours to get the subject served up to several months in order to serve the legal documents. This is where you need to ensure you know what your state requirements are for each of these situations. For instance, here in Colorado, a civil protection order must be served as soon as possible, but 24 hours or more prior to the hearing. In other words, if the hearing for the civil protection order is tomorrow morning at 8 a.m. and you get the papers today at 4 p.m., you do not have time to do legal service of process on them. And here is where it can get tricky. A summons in Colorado for county court must be served 14 days or more prior to the hearing, unless it is a summons enforceable detainer for an eviction matter. Then it must be served 7 days prior to the hearing. But wait, if it's a summons in district court, the law states as soon as possible, which is a bit vague to say the least. What is the rule for summons services in your state? Let me know in the comments down below. The big thing for you to understand that it is incumbent upon you to know the rules, the regulations, and the laws of legal service of process. One of the other requirements for a process server is to not only deliver the papers to the subject, but they must also confirm the identity of the subject being served. And this can be a little difficult, especially if the subject is ducking service or trying to not be served. One way to do this is to do some research, a little OSINT, open source intelligence, and see if you can find a photo of the subject to be served. Many times I will find photos of the subject on social media pages such as Facebook, LinkedIn, and others, or even mugshots we find online. I also usually ask the client if they have photos, especially in civil cases. Many times they do, or they can give you a good physical description of the subject. And I always confirm the subject by name when I serve the documents too, but if they are ducking service, naturally, they will like you. Here is another consideration for doing process serving, and that is when can you serve the papers? What days, what times, and what makes the most sense? Generally speaking, in most states, any time between 6 a.m. and 10:30 p.m. is considered permissible times to do service. Again, you need to confirm with your state to see if there are other restrictions regarding the time of day you are allowed to serve and what to do if there are extraordinary circumstances, such as if the subject works overnight shifts. Equally important is what days can you serve the papers. Many states have limitations, especially when it comes to Sunday serves. Here in Colorado, we can serve papers any day of the week. However, there is a huge exception to this rule. That exception is if the documents being served are not from a Colorado court. If we were serving papers from another state, well, then that state's rules apply. For instance, Texas does not allow service on Sundays. So when we get Texas papers to serve, we need to ensure we do not serve them on Sundays. But what if you are in Texas and you get documents from Colorado that need to be served? Colorado does allow service on Sundays. So can you serve them in Texas on Sunday? The way I handle these is quite simple. I prefer to err on the side of caution, and I follow the more strict rules when there is a conflict. So not only do you need to know your state's laws, but you need to know the laws of other states as well. When you get out-of-state documents, you need to do some research yourself before you go out and do those serves. Here's another big question I get asked often. Can a process server call you? Yes, a process server can call you, and oftentimes they might call to arrange delivery of those legal documents for certain special situations. But generally speaking, a process server will just show up at your home or your business. They'll knock on the door and they will do the serve. A process server may call prior in cases where the client requested them to call, when the person being served knows the papers are coming and is willing to accept them, or in some instances, we will call for certain professional individuals such as law enforcement officers. Now this leads to the question, can a process server serve a subject at their place of employment? Again, the answer is, it all depends. Generally speaking, the answer is yes, but it also depends on the restrictions at the business where the subject works too. Many businesses do not allow personal service on their employees for personal matters or matters not involving that business. So if you show up and ask for John Doe and they ask you why you need to talk to him and you tell them you have legal papers for him and they tell you, sorry, you can't do that here, well, guess what? You can't do that there. If you're having difficulty getting someone served at home and work seems to be the only way, I would suggest you call the place of employment beforehand and see what their policies are and see if they can do anything to help arrange the serve for you. That then leads to the question of who can be served the documents. Do you have to serve the subject personally? And again, you guessed it, it all depends. Every document type has its own limitations dependent upon the state requirements. Looking at Colorado again, most summonses can be served on any family member age 18 or older at the subject's residence. Some key things for this are that it must be at the subject's residence. So if the subject's aunt, Martha, is visiting and she answers the door, well, she can be served. But you must confirm it is the subject's residence and that it is a relative to the subject as well. You should make sure you get their full name. The age of 18 requirement is something that needs to be discussed too. As I mentioned before, if there are conflicts from one state to the next, I usually go with the more strict rule. However, we get a lot of documents from out of state, and many states allow service on anyone the age of 15 or 16 or even 14 in some cases. So for those cases, if I show up and the subject is not home, but his 15-year-old son answers the door, and if the state I am serving the papers for allows it, I will serve the son. I first confirm I am at the subject's residence, then I confirm the relationship and get the son's full name and age so I can document all of that in my affidavit. But if no one answers, can I post or tape the documents to the door? Again, it all depends, folks. Here in Colorado, we have laws that allow for posting for certain documents, mostly pertaining to eviction cases. For most other cases, we are not allowed to do that. But even for eviction papers, I still try at least 3 attempts to do the serve to ensure I have provided due diligence, unless it is a 3-day or other type of posting. For those, I just do a knock and post. Some states allow posting for certain summonses after a set number of attempts. But again, you need to know what those states allow. Generally speaking, though, for subpoenas, they can never be posted or subserved without court approval. So if you have a subpoena and the subject's wife answers the door, even if she says she can take the papers for him, it is not considered legal service. Now this begs the question of how many times do you try to do the serve? Here is a big lesson to learn from my mistakes in the past. When I first started doing serve as a process, I tried until the job got done. And this was very nice for my clients, but not so nice for my bottom line. I quickly found myself spending many hours trying to get the subject served, and I soon learned I needed to set some limits. Most process servers will do 3 attempts on most papers. After that, the client must pay for another round of serves. 3 is a good magic number that most courts will take as doing due diligence, but usually only if several rounds have been done. I think most clients get it these days, but I do still get some clients that don't get it, and they think we are able to guarantee the serve. And this is simply not possible or plausible for any business model in the legal profession. I make sure the client knows that the fee for each serve is on a per individual or entity and per address basis. And if you would like more information on how I set my fees for my PI business, then check out this video.